Mimobi bi akwaba eba Melodies TV so. For this one is going to be quite lengthy, but I want you to stick and stay. A second petition has been leaked. Allegedly, people are alleging say a Chief Justice no, the suspended Chief Justice no, and leaky information. In fact, Sami Jemfi did an interview with Bernard Avle where Sami Jemfi alleged say a Chief Justice na sisi a wano ankasa wo leaky petitions no. Me the first petition no leaked one ebremo Emma make her say it could be a ye from a year said the shining group omo eba betro the reason why a Chief Justice no you know, and I read omonsem including a year afenyuma ken nyama bia or ye what you say afenyuma ken ade a wo ye ne kra they cited that one as part of the case. Now papa bin so ewo hwa ye frɛ no Ayamda Yakubu Akogo or your lawyer. Now papa ne nso ka once initially I say 3 petitioners. Papa no eka petitioners ne ho. Into the petition no eliki. Yen hwen nsɛm a wɔkan ya odigina so a wɔka President His Excellency John Dramani Mahama say only Chief Justice no. Or say His Excellency John Dramani Mahama, the President of Republic of Ghana, Jubilee House, Accra. Dear Mr. President, petition for removal of the Honorable Chief Justice, Her Ladyship Justice Gertrude Saki Tokonu, from office pursuant to Article 146 of the Constitution of Ghana, Section 16 of the Judicial Service Act 1960, CA 10, and the Rules of Code of Conduct for Judges and Magistrates, Ghana, by Ayamga Yakubu Akogo Esquire. Also introduction. I am Ayamga Yakubu Akogo Esquire and a senior police officer in the Ghana Police Service on the rank of Assistant Commissioner of Police. International papa no oye police ni oye police penny. Okay. I am stationed at the National Police Headquarters, Accra. I humbly submit this petition to His Excellency the President of the Republic of Ghana for removal of the Honorable Chief Justice of Ghana, Her Ladyship Justice Gertrude Saki Tokonu from office. Police ni o, where the police ni or petition say yenyi eye mami. I say, I respectfully made this petition pursuant to Article 146 of the Constitution, which provides for removal of the Chief Justice from office on grounds of stated misbehavior, misconduct, and incompetence in the performance of her judicial functions. I say, I further make the petition pursuant to Section 16 of the Enabling Statute, Judicial Service Act 1960, CA 10, on the basis that the Honorable Chief Justice is both member and head of the Judicial Service of Ghana. I say the Judicial Service Act 1960, CA 10, provides for misconduct, stated misbehavior, and incompetence relating to all members of the Judicial Service of Ghana. The Enabling Statute, Judicial Service Act, provides clear basis for disciplinary action, sanction, and regulations of conduct of judges and judicial officers serving in the judicial service. 5. It is pertinent and for purposes of clarity to quote Section 16 of the Judicial Service Act 1960 CA 10, which provides for stated misconduct and incompetence of judges. As a general definition of misconduct, any act done without reasonable excuse by a judicial or executive officer which amounts to a failure to perform in a proper manner any duty imposed upon him as such, or which contravenes any enactment relating to the judicial service, or which is otherwise prejudicial to the efficient conduct of the judicial service, or tends to bring the judicial service into disrepute, shall constitute misconduct. You know, judicial service, obi a woye adwuma ewo eye judiciary bia no. Omo some special embra ewo se wo mo di ye adwuma. Your friend the Judicial Service Act. Inti o kire se Usha Judicial Service Act 1960 CA 10. Sa document na. Maame no kra no wetia samra no. Waye nyama bia wetia samra no. So I want us to go into maame no enyama waya yesi etia samra na eye police penyi opese yeyi maame no yeden efri hoyi. Yenko osi issue 1. Whether or not after delivery of judgment she made demeaning and disrespectful remarks against me as a okay, meba. Let's go back. Actually, as M say we are missing some serious points. Intino no, meba. Or say objective. The code set out appropriate standard of behavior expected of judges, and for which every judge at any of the judicial hierarchy is expected to strive to conform. Or say, and where a member of the public suspects that there has been a failure to comply with the code, to initiate the process for redress and appropriate sanctions against any erring judge. Scope and application. The code shall apply to judges, magistrates, and anyone performing judicial functions. A judge shall respect and comply with the law, including the code of conduct, and shall behave with decorum, propriety, and utmost discretion. A judge shall not abuse the prestige of judicial office. A judge who commits a breach of any rule of this code shall be sanctioned with reference to the gravity of the end. Okay, I see issue 1. Whether or not after delivery of judgment, she made demeaning and disrespectful remarks against me as barrister, court user. I say on 14th November 2023, my case was called for hearing. We are going into the case. So see 2023, your friendly case for hearing. The names of parties and counsel representation were recorded. The proceedings commenced and ended by delivery of the ruling and award of cost. The Chief Justice delivered the ruling dismissing my case as without merit, but no reasoning for the decision. See attached Exhibit C, i.e. the ruling. Into say on your case, it was Supreme Court. Chief Justice no netina case ni so. Your friend the case no okoye. Okoko tre na asem eye bibia. At the end of the day no, Chief Justice no ebo na asem guye se na asem no ababi anim. But Chief Justice no bo na asem no guye no. Chief Justice no ama reasoning bia for the decision. What tre say oba the judiciary ni mu a say judge ebo wa asem gu a o say judge etre nsem wa say etre di nti a wa bo wa asem aden egu. Chief Justice bo na asem guye without any reasoning. Yan trade the entire year bon asemegu. I say I was calm, silent, and seated when she delivered the ruling. Suddenly, I heard her making off-judgment, demeaning remarks against me to the effect that I am incompetent senior barrister. So say Chief Justice ne bon asemegu ye no, ono de wanka hwe. Wa ye kom na watena se na wo dwen ne ho. Obeti an say Chief Justice na hya ase e di natem. Se wo kra no wa bon dodo unim hwe wutiewu. O say eh. Na mami aden ma ye ne boni ana. I say her body language and demeanor making the remarks was equally disrespectful as the comments itself. The comments were made in a manner to ridicule, denigrate, spite, and publicly humiliate or embarrass me as a senior barrister. So I say, oh, here's senior mami no, wo ye ne nim, ni wo kan sem ne senior ya utu se mami ne ye na dwen se wo be gu or no police ni nimu ase pa na nkrofo gu ho na so na mami ni gu nimu ase. I say the remarks were discourteous, disparaging, and disrespectful against my person and professional competence as barrister. The off-judgment comments were abuse of prestige judicial office and constitute state misbehavior, otherwise prejudicial to the efficient conduct of the judicial service and tends to bring the judicial service into disrepute. Also, the comments contravened the code of conduct for judges and magistrates Ghana. Also, a judge shall not abuse the prestige of judicial office, and a judge shall respect and comply with the law, including the code of conduct, and shall behave with decorum, propriety, and utmost discretion. Inti judges no, omo code of conduct omo de yejuma. Code of conduct ne say, men sorry ndidi nkrofo atem e wo court. Judge no e wo se odi hu ni, e wo se obu hu. Nanso wono e ba ne so no, utumu say Chief Justice no when you use code of conduct no. Chief Justice ni di na tem ye. Ati ase. Inti ne issue no issue 1 no. Issue 2. Whether or not a disagreeing response to her off-judgment demeaning remarks could reasonably authorize her to order my arrest and detention. I say it is the case that the Constitution and statute law defined arrest and its circumstances. The law authorizes police officers to arrest with or without warrant a private person without warrant. A private person arrest is narrowly defined in situations where the offense is committed in his presence. Section 9, 10, and 12 of the Criminal Procedure Act 1960 at 30 supports the above statement. Also, a judge is not police officer and generally does not have police's powers of arrest as provided in Section 9, 10, and 12 of the Criminal Procedure Act 1960. A judge's authority in arrest is clearly defined by law, and situation of 14 November 2023 did not authorize her as a judge to make the arrest in the manner she did. It is the case that disagreeing response by a court user to a judge of judgment remarks do not authorize the judge to order the arrest and detention of the court user. I can say with certainty that her order to arrest and detain me was contrary to state statutes, which constitutes a stated misbehavior and incompetence as provided in Article 1461 of the Constitution, Section 16 of the Judicial Service Act, and the Code of Conduct for Judges. Police need someone can say, Emra na Chief Justice no, didi na tem, Emra 1 year Chief Justice ni didi na tem no. Ono nso kasa ya, say no kasa back to the Chief Justice na ana, but nebe na maye wa mi udi matem sa. So your na Chief Justice no order say, yenchi ono lawyer no, police ni penyi na oye lawyer no, yenchi ni ntum, eni ye chi ni tumu. Na wasi, Ghana mratre say, judge eni hu kwan say ye chi obi tum, ye police, ene so ma kwan say ye chi obi. Judge ya odi eni say obi di asem. Udi asem na nipa kono ye guilty a ye hand nipa kono over to police na police we take the course. Manya obone udi matem o court. Me responde say menya ohwe na udi matem ehwo awa ma police for achimi atum. Inti Chief Justice say ade a wo ye no against the law. This is the Chief Justice that MPP for ende omusuama say His Excellency John Dramani Mahama etia mbra no. Meanwhile omuntumi ntre mbra kra His Excellency John Dramani Mahama wotia. And this is what the Chief Justice allegedly was doing to a senior police officer in court. In Senshisha Adekamu, I say, I did not commit any criminal offense in the presence of a judge to order my arrest pursuant to Section 17 of the Criminal Procedure Act 1960, where an offense is committed in the presence of a district magistrate within the area of jurisdiction of the magistrate may arrest or order a person to arrest the offender and may, subject to the conditions of the grant of bail, commit the offender to custody. I was not person for which facts were adduced on oath authorizing her to order my arrest in pursuant to Section 18 of the Criminal Procedure Act. Within the area of the jurisdiction of a district magistrate, the magistrate may arrest or direct the arrest in the presence of the magistrate, or direct the arrest in the presence of the magistrate. A person whose arrest on a warrant could have been lawfully ordered if the fact known at the time of making or directing the arrest had been stated before the district magistrate on oath by another person. 72. I say it is submitted that the conditions in Section 17 and IS of the Criminal Procedure Act 30, which grants authority for a judge to order arrest, did not arise when I was arrested. It was wrong to order my arrest. Respectfully disagreeing with her off-record comments, do not warrant arrest and detention. The order of arrest was contrary to Section 9, 10, 12, 17, and 18 of the Criminal Procedure Act 1960, Act 30. Into what police nina, what threatening semni ni so. Say, Ghana mratre say, obi ye se ni se ane wasi ye chino, obi ye se ni se ane wasi ye chino. Judge no, manyane bone, odi matem, atemdidia wo odi mi no, ena minso me kasa wo court so tre say, me mfo atemdidie ne so, eho na wama ya chimi atum. Inti, the policeman is now showing the articles and the laws to show say chia wachi mi tu mu no etiambra emra amma Supreme Court ne kwan say sorry Chief Justice ne kwan say e wo say wo ma ye chi mi tum sa bone be na me yeye na se wudi obi atem na nipa ko na kasa atem didi a wudi no sebe enye sa na ote a ye chi nipa kro ni tum. Hey, I say it is my humble submission that the arrest was influenced by anger, prejudice, personal resentment, and malice. It contravened Section 16 of the Judicial Service Act 1960 CA10 and Code of Conduct for Judges and Magistrates Ghana. It was abuse of power and absurd. A judge shall not abuse the prestige of judicial office, and a judge shall make every effort to ensure that his conduct is above reproach, ill the view of reasonable, fair-minded, and informed persons. Nto se wo ha Chief Justice no chia wo ma ye chi ni tumu na Chief Justice ni buefu utumi hu ne se na Chief Justice no wo ba court wo kra no na case no e she ni trim de dada se wo be die tia eye sa police ni nti wo ba ne kra na nye police ni nsem kra na wo ba betie prejudicial a personal resentment. That's how to me when say, or personally, no, or time police needed an answer na war back. Unim say ye need a man a time no say ye dien unim the wire Chief Justice no. I say it is my submission that the arrest and detention breached the law on arrest. It violated my constitutional rights against unlawful arrest and detention. It was prejudicial to the efficient conduct of the judicial service and tends to bring the judicial service into disrepute. Thus constitutes stated misbehavior and incompetence as provided in Article 146 of the Constitution. In the second issue, the Chief Justice the first issue, Chief Justice ni di natem. Second issue, Chief Justice ni di natem war can be no. Chief Justice no then no. So let's go to the third issue. Or the third issue, whether or not a mere response disagreeing with off-judgment demeaning comments reasonably constitute contempt of court. Inti the Chief Justice no Chief Justice no so charging with contempt of court. Also, it is the case that the Chief Justice delivered the ruling of the court and afterwards made demeaning remarks that offended me. I respectfully submit that I did nothing in response to her comments, save respectfully responding to her comments in 2 words. I disagree. Intino or kase Chief Justice nin semwa wakan ye ni no or no dear winding atem. But the only words are or Yusuma Chief Justice and say I disagree. So atemidia wudi mini nano asemo make and say oh me mfuaso. Atemidia wudi mini mfuaso and no keke. Chief Justice Nija. I said this innocuous response, disagreeing with her demeaning comments against me, made her to furiously order arrest him. I was arrested pursuant to her orders. It was say I disagree keke wakan Chief Justice ni fu. I disagree keke wakan no. Chief Justice ni fu. And the mon chino. Course so am ye chino. 72. I say it is the case that my arrest was absurd because it is completely unreasonable to arrest because of response disagreeing with off-judgment demeaning comments by a judge and constitute abuse of judicial office and authority. I did not disturb the court proceedings, save responding that I disagree with her comment against me. I did not obstruct court proceedings by disagreeing with the comment. It was say or no there. Asemo kan I disagree no. Enya ade bia obeka se wakasa de din bia obeka se enu hunti na court no muntumi nyom adwuma. Enya ade a eya ade bia obeka se o asoden bi udi matem na me se atem dia udi mi ne de enye sa na mete memfo aso. Wo se ye nche me. I say I did not in words or by conduct disrespect any judge by disagreeing with her comments against me. I did not challenge the authority of the court by disagreeing with her belittling comments against me. I did not challenge or insult any of the judges by disagreeing with the off-judgment disrespectful. I never disobeyed orders of the court or by disagreeing with the comments. I did nothing unreasonable or contemptuous of the court. Nti senia waka no sebe mendi atem manka ne bone adia meyeye na nya adia bia beka so onipenya kasa by heart manya saa wedi matem na me se atem didi a wudi di media memfo aso ehwa Chief Justice Eja. I say a fair-minded and reasonable informed person would not agree that disagreeing with a judge comment is arrestable. It is respectfully submitted that the arrest is contrary to the code of conduct for judges. A judge shall make every effort to ensure that his conduct is above reproach in the view of reasonable, fair-minded, and informed persons. I say, contempt of court, as provided in Article 12 of the Constitution states, no person shall be convicted of a criminal offense unless the offense is defined and the penalty for it is prescribed in a written law. 12, Clause 2, Clause II of this article shall not prevent a superior court from punishing a person for contempt of itself, notwithstanding that the act of omission constituting the contempt is not defined in a written law and the penalty is not so prescribed. I say it is submitted that contempt of court, as provided in Article 12 of the Constitution, is exercise of discretion It is the case that being discretion, its exercise must be in accordance with the Article 296 of Constitution, which provides, where in this Constitution or in any other law discretionary power is vested in any person or authority, that discretionary power shall be deemed to imply a duty to be fair and candid. The exercise of the discretionary power shall not be arbitrary, capricious, or biased, either by resentment, prejudice, and personal dislike, and shall be in accordance with due process of law. Nti Ghana mmara say, ye di tumi hye onsa na wo di tumi ni ye adwuma. Hwe say ebia wanfa wotan, say wotan nti, nipa kro we metan nti, and then yama me tumi say me chief justice no, me tumi ama ya chi na tum. Nti nipa ko ne ya ade na say, enya ade wo se ya chi ni tum kra na mama ya chi na tum. Nti wo koti say Article 296 no, etre. Nti chief justice ne bu Article 296. I say, where the person or authority is not a judge or other judicial officers, there shall be published by constitutional instrument or statutory instrument regulation that are not inconsistent with the provision of this constitution or the other law to govern the exercise of the discretionary power. I say, it is the case that contempt of court is discretion which is vested in the court, and its exercise must be fair, candid, and not arbitrary, capricious, prejudicial, or personal dislike, must be in accordance with due process of law. I did not commit contempt of court within a reasonable meaning of Articles 12 and 296 of the Constitution to be arrested on her orders. The order of arrest was prejudicial, abuse of judicial office, and was wrongful. I said the arrest was never in exercise of proper or reasonable contempt of court, as envisaged in Articles 12 and 296 of the Constitution. Thus, disagreeing with off-judgment comments is never an insult or disrespect or contempt of court, and did not require arrest by reasonable exercise of discretion or contempt of court. It is any work no. So we did or respond the way the matter may respond there, and interest contempt of court, and interest me di watem, and enya bone any kwanse wo order me for contempt. See, issue 4, whether or not the order of arrest and detention was her spontaneous and unilateral decision, not the court's decision. Okay. See, it is the case that I respectfully disagreed with the Chief Justice's off-judgment demeaning comment against me. She spontaneously, unilaterally, and without inviting the other members constituting the court, reacted to my disagreement orders. Arrest him, arrest him. Her order to arrest me was immediate, instantaneous, spontaneous, and unilateral, where there was no imminent threat to life or imminent disorderly conduct emanating from me, and there was no appearance of a reasonable judicial agency for her rash order to arrest without the involving of the court properly constituted. Inti, unse or trese case no na Chief Justice ni penetina case award dey akọ Supreme Court na Chief Justice ni penetina so. Na se judges 3 enetina case wa se decision e ba judges 3 ni na wo se omo ekoko decide. Chief Justice na order wo ka say arrest him no. Chief Justice now consulted the other judges. Instantaneous. Enimu ho na Chief Justice ka arrest him. Not just the Chief Justice ne kra no. Wembu court embra tre say judges 3 etina asem ne so a. Sa judges 3 no ebe decide on the case. Chief Justice na kasa de ne pe. Edi ni tumi decide on say ya arrest no. Na ki pese ye chine for contempt mpo a. Na ke say other judges no can be. But instant one na Chief Justice Nankasa decide say menkwa ye judges 3 and ye judges bibra ye case we so there now so menkwa mema order say ye nche no. I say the court was constituted by 5-member panel. 95 judges near 5. Chief Justice ni nsiki the other 4 judges. Ono ade ne pe eka say ye nche ni pakro we ntum, which I mean who dwen ho he's right, because 5 judges need the case. How is it that just a single person would decide? I mean, it's against the laws of this country. What you say? It was said the court was constituted by 5-member panel. It is submitted that the panel members may probably and reasonably not concur with her decision to arrest. Hence, her rush to unilaterally order the arrest. It was said Chief Justice Ninim say, other panel members, judges ne wo hono, or katro mo say yenchi or no papaya. Judges name pene because judges nbeka say, oh, so undi atem. Didn't ya ne yenchi no. Eno hunti ena Chief Justice ne de ono ankasa ne pe order say monchino because no nim say other judges no omonfo. I said the involvement of the other panel members may have averted the arrest and detention. The order to arrest and detain is such a serious and substantive matter by itself, with distinct course of action which requires the court's decision, not unilateral action or prejudicial decision or by rush of anger or personal dislike. And what the police is saying is true. So you see, you are changing the background that brew. Change decision be abeka say 5 judges are your tickets ni so amepe me take that decision no that be. I was say judges ni can be. And you see what I like about this thing, and it's a committee na ya set this here no. You be free papa not the answer but not the evidence the chief justice in the year no or the aba or the barrier. Judges no most tena case so no omo so beba under oath they will also come and say the truth say omo pene so say na ka chief justice ni ma ye nchi nipa kro na na. Nti eno so ehon so judges no beba or say her unilateral decision to arrest was out of ego, prejudicial, arbitrary, and personal resentment. She assumed unto herself powers of the court without recourse to the court. The arrest was contrary to the code of conduct for judges. A judge shall respect and comply with the law, including the code of conduct, and shall behave with decorum, propriety, and utmost discretion. A judge shall not abuse the prestige of judicial office. I say it is respectfully submitted that the arrest was unreasonably unilateral and resulted in my humiliation and embarrassment, which constitutes stated misbehavior and incompetent performance of duty, otherwise prejudicial to the efficient conduct of the judicial service and tends to bring the judicial service into disrepute. Issue 5. Whether or not she failed or neglected to record in the court's record her order of arrest and detention. Chief Justice in case way, Assembly PA. I say the basic task of every judge is to keep accurate and true record of what transpired in court's record book. The Supreme Court is a court of record. Judges are required to keep accurate and true record of proceedings. Failing or neglecting to record constitutes stated misbehavior and incompetence and non-compliance with the Code of Conduct for Judges and Section 16 of Judicial Service Act CA 10. The evidence as admitted in the search report is the Chief Justice did not record her order of arrest and detention. One say, so we notice here, court case biano, na judges no, omo recording sem. Die esi wo court biano, was say a year on record. Inti me melodies amiti hei, se me pese me head ye course wo court a, me kwaje court proceedings na, me hu die course ni na. Ye say say Chief Justice no order say ye nchi say nipa kro enwie no. Chief Justice ni hu say ono kra we di bono no Chief Justice ni di bone. Inti ono ne records mu no, wan fan shem say oh me ma order say police ni ye nchi no. Me bufu ye na me ma order say ye nchi no because onim say o di shemu a. At the end of the day, ye be hu ni say Chief Justice no officially no wa indict ho say we di bone. Inti Chief Justice no official records no oyi sa de ni free mu. This is the allegation of Papano Edituja. Or say the evidence, as admitted in the search report, is the Chief Justice did not record her order of arrest and detention. Was this record of arrest and detention of applicants in court's record book? No. Respectfully, there was no proper record of what transpired in court before and after my arrest and detention. Chief Justice no. One draw. I say it was deliberate failure to record, thereby denying me a decisional record of the court's transgression which could enable me challenge the arrest in a review proceeding. It is the case that without evidential record that I was arrested and detained, I cannot take review action at the special and final review bench of the Supreme Court in respect of her excesses. Her failure to record contravened the Code of Conduct of Judges and Magistrates, Ghana, which provides a judge shall devote his professional activity to judicial duties broadly defined, which include not only presiding in court and making decisions, but other judicial tasks essential to the court's operation. A judge shall endeavor to perform all judicial duties, including the delivery of reserved judgments, with reasonable promptness. I say her failure or negligence to record her comments and order of arrest was to cover up her transgression, which conduct constituted dereliction of duty to perform judicial acts essential for the court's efficient operations, constituting stated misbehavior and incompetence. Issue 6. Whether or not she fabricated evidence by approving the making of statements and entries in such reports to pervert the course of justice and cover up what transpired. Hey, we serious. Say the Chief Justice no fabricate evidence. Chief Justice necessary evidence be so that no Chief Justice has there. Hey. I say it is strict law that making false statements or false entries in official record constitute fabrication of evidence, which is criminal offense. The fabrication of evidence in official record, such as such report, intended to deceive public officers or obstruct justice or pervert the course of justice, is criminal offense. A such report is official judicial record, and it is essential that it reflects reality and what it purports to mean. It is imperative that entries or statements in any such record must reflect accurately what it purports to mean. Otherwise, it may constitute criminal conduct or offense. Section 213 of the Criminal Offences Act 1960 Act 29 provides that fabrication of evidence or the making false statements or entries to deceive or obstruct or pervert the course of justice is crime. Or see, a person who fabricates evidence with intent to defeat, obstruct, or pervert the course of justice in a proceeding commits a criminal offense and is liable to the same penalties as if that person had committed perjury in that proceeding. Section 214 of the Criminal Offences Act 1960 at 29 defined fabrication of evidence as a person fabricates evidence if that person causes a circumstance to exist or makes a false entry in a book, an account, or a record, or makes a document containing a false statement or forges a document with intent to mislead a public officer, judge, or jury acting in a judicial proceeding. It has been established that in open court, the Honorable Chief Justice on 14th November 2023 ordered my arrest and detention. Indeed, I was arrested and detained pursuant to her order. I was subsequently discharged and released without charge or trial after the arrest and detention. The media was present in the court and reported the arrest and detention. The media reported the reason for the arrest inaccurately and misled the world. I sought to obtain the accurate record at the court registry by means of such report. It was my expectation to have answers that truly and accurately reflect what transpired in court, yet I was disappointed in that respect. The search report stated that I was never arrested and detained. The search report filed on 18th December 2023 stated, was the applicant arrested in courtroom on 14th November 2023? No. Was the applicant detained outside the courtroom on 14th November 2023? No. Was there record of arrest and detention of applicant in a court's record book? No. Into what say, ye chini tu muwie ye no. That day, journalists reported say indeed they are chino. Na afe wo wie ya wo be court judicial service wo say wo ko search book court report mu na we hu say reason ben is state say ye chino sa day no call ye no ye say court report nim no ya ntro say ye chino. Nti eye falsified report. Unim say wa chini pa kro no die ntia na court report nim no wakwa kwotwa ntro say ya chini pa kro no na che say you are falsified evidence. The Chief Justice no another case kesia etia no. Or say, I did submit the search request to the registry of the court. She received it and informed me that it would be sent to the Chief Justice for a direction and answers. Consequently, the search record was answered under the direction, supervision, approval, and consent of the Chief Justice. The search record answers, as approved and directed by her, contained false statements or false entries to cover up what transpired. The answers in the search report were false and intended to deceive, obstruct, and pervert the course of justice and contrary to law. It is submitted that the Chief Justice knew and approved of the false statements in the search record. She knew the answers were completely false. She knew the answers in the report did not reflect what transpired in court, yet she authorized and approved same. She knew the statements and answers contained in the search record was fabricated evidence. She knew that search report. Also, she knew that search report is official documents to be presented in a proceeding before a public officer or judge in a proceeding. Yet, she supervised its fabrication with intent to deceive, obstruct, and pervert the course of justice, contrary to law which constitutes stated misbehavior as provided in Article 1461 of the Constitution. Hey! Into when an MPP for say, Chief Justice don't do bonibiano. So this is what they are saying, say, there is no prima facie case against the Chief Justice. Papa where I a friend of Ayamga Yakubu Akogoi into your papa na keye ni si yanka weni beji. But sani America, it is his word against that of the Chief Justice. But basically, no, papa no, ninsem ni, what I say, ninsema wadi ababe tu jani, Chief Justice no aid in attempt and all that. What I say, papa no ninsem wadi tu ja, no. Basically, you now understand the whole case. Policeman, no, you now understand the whole case. You know, I mean, basically on grounds of sa adie we ya call so court no, and now ode sa 23-paged petition no, 23-paged. Ode a 23-page petition about at least the meat of the whole thing no, because we did 23 pages in and then you be free her. But the meat of the whole thing no, makenkan ama wati asye. Inti Ayamga Akugu Esquire. No. Won't try my comment box ni mo. Me da say.